All right, well, maybe we'll make a start now. Hi everyone, welcome to Spruson and Ferguson's second webinar in a three-part series titled IP Strategy Roadmap for the Food and Beverage Industry. We bring this to you in partnership with the Riddet Institute, Centre of Research Excellence, and with funding through the High Value Nutritional National Science Challenge. My name is Mike Zammit and I am a principal and the leader of the Chemical and Life Sciences team at Spruson and Ferguson, Australia. Our presenter today is Dr. Peter Brown, who is a fellow principal in our team specialising in the food and beverage sector. Peter has considerable experience working with his food and beverage clients to help develop IP strategies and progress commercially important patents, both locally in New Zealand and Australia, as well as in target overseas markets. Prior to joining us, Peter worked in-house as an innovation manager and a patent attorney for a large multinational FMCG company, and also has been a co-founder of a startup food technology company. Today, Peter's second webinar will walk you through the patenting roadmap, right from ideation to commercialisation. It will cover the types of patents he most commonly sees in the food and beverage sector with real patent examples and patent claims, to give you context to what might be patentable in your R&D portfolio. You'll then run through a handy tool for deciding whether to patent or not, and then sum up with a case study. Of course, remembering that nothing in this webinar should be taken as legal advice, and you should talk to an IP professional to work through your specific circumstances. As a firm, Spruson and Ferguson's patent attorneys have extensive experience filing and prosecuting food and beverage related patents, for example, in the fields of dairy, milk and milk solids, yeast, wheaten grains, fats, oils and lipids, natural and artificial sweeteners, proteins and amino acids, as well as manufacturing, storage and packaging technologies. In terms of logistics, today we are using Vimeo's webinar settings, meaning everyone in the audience is on mute with the video turned off and nobody can turn either of those on. There is a live chat function at the bottom of your screen, and you can use that to submit questions to us during the webinar, and I'll raise as many of those as I can at the conclusion of today's webinar. We will also follow up with individuals with answers to any questions that do not get answered today. Today's webinar is being recorded, and we will send all registrants a link to the recording over the coming days. And with all that in mind, I'll now hand over to Peter to get the presentation underway. Thank you, Peter.
Thank you, Mike, and kia ora to everyone in New Zealand, and welcome to all our guests as well joining us from overseas. It's very nice to have you here today for the second webinar in the three-part series. So as the title shows actually on the screen, this initial roadmap report and webinar series was intended or is intended for the New Zealand food and beverage sector, but obviously the learnings and the approaches are very applicable for other countries as well. So just because it's got New Zealand in the title here doesn't mean you should switch off at this point. So please stay tuned. So I will get started. So as we already have gone through the building blocks, that was on the 1st of February for those of you that managed to join for that one. Today we're looking through, as Mike said, the patenting journey and actually trying to make some money from it. So this is all the way from ideation all the way through to in market, and the key kind of milestones that we look at, timing, cost considerations as well. And then finally, the third webinar, which is on the 24th of May, and we'll send out the link to that, is really looking at it, avoiding the common pitfalls and when things can go wrong. And we'll be looking at those in particular. And that's obviously a very juicy topic and some really good learnings from that as well. So if you can make that, I strongly recommend you join for the third webinar. So just recapping what we looked at in webinar one, what is intellectual property and why is it so important? We looked at it specifically in the New Zealand context, but obviously there's a lot of things that will resonate with other countries as well that are very focused on the food and beverage export market. We looked at kickstarting your IP strategy with some basic strategies. Relevant types of IP for food and beverage companies. We just ran through the most basic ones, but also some other types of IP that companies often don't think about. For example, food health claims, which is very relevant in the food and beverage sector. We looked at the trademark and design roadmaps, but today we're going to specifically looking at the patenting roadmap and everything about that. And we finally summed up with a case study on Gutsy, which we'll be looking at a different case study today. And if you're very quick at typing, you can actually write down the link to the webinar 1 here. Otherwise, there will be in the recording, as Mike said, and we will send that through. So you can, if you did miss it, you can watch that again, or you can watch that, sorry. So today, what we're really going to be looking at is the patent roadmap, types of food and beverage patents that I often see, with real examples. That handy patenting tool, a decision tool that Mike mentioned. Show me the money, how we actually make money from these patents, and they don't just sit in the drawer. And then our case study story time, if we've got time, will be about a husky, and I quite like this story, so hopefully you guys can stay tuned for that. And as I said, webinar 3 will be going through all these different other considerations as well that come up time and time again. So recapping, what is a patent? For those of you that didn't make it, it is essentially gives the owner of that patent the right to prevent others from making, selling, using, importing, or otherwise exploiting the invention that's claimed in the patent as granted. And it's specifically for that country, so patents are territorial. And that would last for 20 years, which is the monopoly that's granted. It's really important to recognize that gaining a patent does not necessarily give you freedom to operate. So it's really important that you, as well as protecting your own intellectual property, that you actually look to see whether or not you potentially could be infringing other people's rights, be it a patent or some other form of intellectual property right. So I'm not going to go through all the pros and cons, but probably just a couple to call out in the context of today's webinar. One of the kind of key pros around patents is that they're most commonly used in the food and beverage sector in a positive way, and I'll be going through some of those today, instead of enforcement action. Nobody really wants to get into enforcement action, although obviously you can, and that can be one of the kind of key purposes of a patent. But in today's day and age, companies are more often using patents as a positive tool to drive collaboration, to gain licensing deals, to develop new opportunities. There's obviously some cons with patents as well, and I'll be going through a couple of those in relation to what I'm talking about today. Obviously, they can be expensive. They can be quite slow in getting them, but there are ways of speeding that up, which I'll go through. They are territorial, as I said, so you have to actually file a patent application in each country that you want to have commercial protection. And obviously litigation, if you do go down that path, can be obviously very expensive as well. So I first wanted to kind of show you what the patenting roadmap looks like, to kind of give you the big picture, and then we'll kind of go down into a bit more depth into some of the considerations. So obviously you first come up with an idea. You might be sitting on a toilet, and obviously not in the food and beverage space. You're not going to be sitting on a toilet thinking of a new idea, but that type of thing. You might come up with this bright spark of where a new idea that you want to commercialize and potentially protect. Typically, that's not how it really happens. It will be in a kind of a team environment where you're developing a new R&D pipeline, and you really want to kind of invest heavily in a new project, and it could involve a lot of scientific rigor, a lot of testing, a lot of methodology, potentially even clinical trials. There's a lot that goes into that, which ultimately leads to this new idea or concept. And in this roadmap, it actually shows meeting with a patent attorney following that. But often what I say to a lot of my local clients is it's best to get the patent attorney actually in the room while you're kind of ideating, and even before you kind of start your R&D journey. And the reason is because doing some preliminary searching and kind of getting an idea of where you're going with your intellectual property strategy can help guide where you're actually going to be going in your R&D pipeline. And that's a really important consideration. Big, multinational companies are spending millions of dollars developing new concepts and new ideas. So it's really important they have that kind of upfront IP lens, an IP strategy before they get too far down the track. So ultimately, you will be doing that searching at some point, or you should be. That will typically be in the form of kind of a freedom to operate assessment. Are there any other patents that you could potentially infringe, and how could you develop your product or your R&D to avoid that infringement? And secondly, another key one that most people will be thinking about is, if we do want a patent, is this potentially patentable? And that means it needs to obviously be novel and inventive and a few other factors. So that's called like a patentability search, and it's a common thing that patent attorneys can help clients with. If both of those are looking really promising, then typically what will happen before you go out and commercialize and before you go out and disclose, for example, in a scientific journal, you need to file a patent application because it has to be new. So if you've gone and published something, then that will really prevent you from gaining any kind of patent protection. There is a grace period in some countries, a 1-year grace period for if you do disclose, but we typically will recommend to clients not to rely on that. It's kind of a fail-safe, it's kind of a backup option if it accidentally does happen. The reason for that is that some countries don't have grace periods. So although you might be able to get protection in 1 or 2 countries that do have those grace periods, it might not be a smooth sailing around the world. The provisional application needs to have sufficient disclosure and clarity in it for somebody skilled in the art in that industry, for example, in the food and beverage industry, to be able to replicate that invention without any kind of inventive step of their own. So there has to be a fair degree of disclosure and support in that provisional specification. And for example, New Zealand and Australia are pretty strict when it comes to this, but countries, in Europe and China, for example, are even stricter. So when we're drafting patent applications and we're for a client that's got an export lens, we're always drafting patent applications to kind of meet the threshold for all of those markets. So once you've filed your provisional, essentially that's your stake in the sand, so to speak. You can, if you want, then go and commercialize and disclose your invention. You've actually got a year's period to conduct further R&D, which you can then add to your complete application, which is a year down the track. That's really useful for boosting up the support of what's in the original provisional. So for example, you might want to, if you've got a patent claim which has got a range, for example, and you're trying to protect a range of something, you can kind of boost up the support by testing out a few different points within that range. At that 1-year point, you've then got the ability to file either directly into each country of interest. So if you've only got a couple of countries, maybe just USA, or maybe you just want to get protection in Europe, you can file a regional application in Europe and US. But if you're unsure at that point, and potentially you think there might be a lot more opportunity at that, in other countries, what most people will do is file a PCT application, Patent Cooperation Treaty, which allows you to delay that decision by another 18 months. So essentially, it's 30 months from your original provisional date. You've got to decide to just where to file in each individual country. So that's a tactic that most companies and individuals will take if they're very focused on the international market. That's the time point as well where it's considered to be your filing date, and that's when your 20-year patent term starts at that point. The next key milestone is at the 18-month point from your provisional, and that's when your patent application will ultimately get published for the first time. It will get published later down the track as well, but the first time it'll get published will be at that kind of PCT, typically, if you file the PCT at that 18-month point. So it's really important that if you've kind of still unsure whether or not you want to go through the whole patenting process, you can still withdraw the patent application at that point to prevent publication, and you can keep it as a trade secret if you've kept it confidential up until that point. The next, I've just realized actually this roadmap is actually missing a point. So as I mentioned, at the 30-month point is when you have to enter national phase in each country of interest. Some countries it's 30 months. Some countries it's 31 months. And generally speaking, although this is not 100%, the 31-month countries are kind of the Commonwealth countries. US, for example, is a 30-month country. So it's important to be aware of that, although your patent attorney will obviously be across that. Once the application is then filed in each country, the national examination process starts to kick in. Some countries it's automatic; it'll automatically get examined, like in the U.S. Whereas a lot of other countries, you have to actually request exam by a certain time point, at which point it then goes into a queue to get examined. And then there's typically a back and forth between the patent office and the attorney, or if you're managing it yourself, between yourself and the examiner, and they'll kind of do a search themselves. They'll identify whether or not they consider any prior art or documents to be, relevant to your claimed invention. And then you kind of go back and forth with the examiner to argue as to whether or not the patent should be allowable or not. And then ultimately, all going well, the patent office will accept the claims. You can obviously, as part of that back and forth process, you can either submit arguments or you can submit amendments to the claims. So typically those are narrowing amendments that overcome any objections that the examiner has raised. That will then, if all going well, will lead to acceptance and then grant of the patent. And some people say, well, how long does this take from start to finish? And typically, if you kind of follow the process without any kind of pushing it forward faster, it would probably take about 3 to 5 years, depending on the country. But there are ways of speeding it up. So there's this new thing called the patent prosecution highway. So if you do get allowance of a patent in one jurisdiction, you can use that to speed up the process in other countries if you want. Some people don't want to. They want to delay costs as much as possible. Other people want to get their patents granted as quickly as possible, so it boosts up confidence, for example, in investors, or they might want to, deter a competitor in a particular market, and so they want to get that granted patent quicker. So, once that's granted, further down this pipeline or this roadmap, you'll see I've kind of indicated a couple things. So you can mark your product as being patented, you can attract investment, you can sell or license your IP and stop competitors. I think probably importantly, just bear in mind that some of these things you can actually do when the patent is still pending. So you can obviously, most importantly, you can still attract investment. If you're a startup, investors will still see it as important that you've even filed a patent application, even if it's pending. You can still arrange licensing even on a pending patent application. You can mark your products as pending still, so you can still deter competitors even with a pending application, but you can't enforce it. That's an important thing to point out. So obviously there's a lot more detail than what I've just gone through. I think the other thing that obviously people are really interested in is how much does it cost? And it really depends on the circumstance, but probably the key areas there where costs creep up is obviously when you file the provisional. Typically the costs might be, depending on how complex the invention is and the circumstances around it, and obviously depending on who you're working with, but it could be anywhere from $5,000 to 10 or 20 grand, depending on the complexity. The next key stage where costs creep up are around the PCT stage, and PCT official fees are around about $5,000. And then you've got any fees associated with if you're adding data to the specification or you're amending any of the description, there'll be costs involved in that as well. Then probably the third and the most expensive phase is once you've entered national phase. So the cost for filing national phase and then prosecuting in each country can be quite expensive. And typically, the way I explain it to clients is that the bigger the market, generally the more expensive it is. So US and Europe are very expensive comparatively, and any countries that require translations like Japan and China, for example, can get quite expensive because of the cost of translating the patent application. So that's hopefully that kind of gives you an idea of costs. And that's why it's really important to kind of, as I'll go through in the next couple of slides, why it's really important to kind of understand where the money's coming from. Do you have the budget? Can you get additional funding or licensing in place before those bigger costs come up? So now I'm going to switch over and talk about some of the types of patents that I see in the food and beverage space, and I'll give an example of each. So the one area that you most commonly see patents in the food and beverage space is for new compositions or substances. And as an example is this perfect day patent. This is to do with the recombinant milk proteins that everyone will be aware of in the food and beverage sector. They've got a host of patents around the space. And what you can see down the bottom there is the first claim. This is actually still a pending application, so this might not be the ultimate claim. It might be narrowed down to have more essential features in it. But it's obviously to do with that new substance, and then they'll probably have composition claims as well. So a composition which includes a recombinant beta-lactoglobulin comprising blah blah blah. And then they'll probably have 20 or 30 claims with different features in it, from broadest down to narrowest. The next one is the new uses of a known compound or substance. And typically, let me just get my notes for this. So this could be in the sense of new health outcomes, so new uses of a known compound, shelf life. So it could be like compound X, which improves the shelf life of something. Could be stability, sensory attributes in the food and beverage sector, those types of things. So just because the compound or substance is already known, you can still get patent protection for new uses of known things. And that's a very common area as well in the food and beverage sector. So an example of this is Arla Foods patent. This is in relation to a method of preventing physical instability of a heat-treated dairy-based product where it includes one or more polyphenol compounds. Again, this is a pending application, so as it goes through, it might get narrowed even further down. So some of these you're going to go, well, surely this is not novel, but potentially, that during that process, the claim will get narrowed down. I should point out, actually, just going back to this one, the perfect day one, you probably have heard about this, or at least in the patent sphere, people have. The perfect day patent application was actually opposed by Fonterra. It wasn't this one; it was a different one, and it was successfully opposed on the grounds of a lack of support. So the specification didn't have enough detail in it there to allow somebody skilled in the art to reproduce the invention as claimed. So the next area of interest is the preventative therapeutic treatment, and this is an area that I'm personally love working in. I get really passionate about this space, and obviously in the area that high value nutrition is involved with, it's looking about preventative improvements using food and beverage. So an example of this is Nestle's patent. So there was a huge amount of these patents that have come through in the last 10 or 15 years to do with the human milk oligosaccharides. And we saw a lot of that in the high value nutrition patent landscape analysis that I was doing in this space, particularly for infant nutrition. It wasn't just Nestle. There was a bunch of companies following these left, right, and center. And, it's a really big commercial opportunity. So again, you can see here, this is this claim here you can see at the bottom is actually drafted in a European style fashion. So it's a composition for some use, in this case for enhancing bone development and or bone strength in a subject. In some countries, these claims are not used. You can use them, but say for in Australia, the wording for is not considered to be limiting. And so the way that this will be addressed in Australia is converting this into a method of administration or a method of treatment, which is allowable in Australia, but not in Europe. And that's why it's written this way in Europe. Sorry, this would have been this is actually a PCT application at this point, but they've obviously got the claim there in the European format. In New Zealand, method of treatments are not patentable, but in this case, as you might notice, this isn't actually, at least according to Claim 1, doesn't seem to be focused towards a therapeutic use for somebody that is ill or sick. So in New Zealand, sometimes you can get away with these claims if you can convince the examiner that the method of treatment is more for somebody that is a healthy individual, and it's a supportive type of method of treatment. Sometimes those claims can be allowable in New Zealand. But yes, every country has different requirements in terms of method of treatment, and some countries simply do not allow them at all. Methods of manufacture, this is obviously another big one, and is probably the one where you need to decide whether or not you think it makes sense to patent it, if you think it's likely that it can be reverse engineered, or whether or not it's something that can be held as a tightly held trade secret. But you still see a lot of these types of patents in the food and beverage sector. Here's one from CJ. I'm not going to try and pronounce their full name. But it's a method of manufacturing this is from South Korea, method of manufacturing a composition of fermented soybean products. And again, I actually had a look at this patent family online before the webinar, and the patent wasn't allowed in the US, but in a number of Asian countries it was allowed, and certainly had a lot more limitations to what is shown in the first claim there. So during the examination process, the examiner and the applicant narrowed it down to what was considered to be a patentable invention, above and beyond what was known in the art beforehand. You also see new machinery or tools in the food and beverage sector. So this is an example of one mechanically harvesting fruit species from Italy. And again, this is something that we see regularly. And in Australia, the agricultural business is huge, like in New Zealand, and there's a lot of patent protection in this space. And then finally, and this isn't an exhaustive list, but these are probably the most common ones that I see. You also see, packaging-related inventions. These come up time and time again, and as a way of differentiating over your competitor. Perhaps it's from a tactile point of view in terms of the consumer experience, or it might be that it's something around sustainable technology. For example, this one here is to do with a self-full disposable coffee pod that's also biodegradable. Or it could be to do with extended shelf life, again, kind of in that sustainability space, and also potentially saving company costs as well if you manage to increase shelf life. We actually see a lot of patents in the space of extended shelf life, with bioactives in packaging to prevent microbial growth. That's another big area. And there was also a time, it was about 5 or 10 years ago, we saw a lot of patents come through, interestingly enough, with straws that have essentially flavor, and you can, in edible straws. So there's this, just this rush of patents that came through all of a sudden. So those types of things you often see, not just packaging, but actually other types of devices, so to speak, in the food and beverage sector. So now switching tacks and looking at, well, okay, now I know where I potentially could patent, and the roadmap. Should I even bother patenting? Is it worthwhile given my circumstance? So I guess the first thing you need to consider is it actually an invention that could be patentable? And I think ultimately that this is hopefully you guys can see this, but is it actually a technological invention? Does it have some kind of technology to it? Is it a discovery? A mere discovery is not considered to be a patentable invention. But if you can apply that discovery, you can, and then the application of that discovery is new, that potentially can be patentable as long as the claim is worded appropriately. And there's this other phrase, artificially created state of affairs. Is it considered to be something made by man and doesn't exist naturally? That's the other way of looking at it as well. So if the answer is no, it's probably not going to be patentable, but of course, go and speak to a patent attorney and get a second opinion on that. So if it's a yes, then another question you need to ask is, do you actually own that invention? So has there been an assignment of intellectual property rights? If you're collaborating with a university, for example, you need to check the clauses in that agreement to see whether or not you actually have the right to file a patent application, or does the university or the other entity that you're working with own the intellectual property rights. That's really important. And we, as we'll be talking about in the the third webinar, these types of problems come up time and time again, and it's really, really important to iron those out as early on as possible. Another thing to look at is your actual employment agreements that you might have internally. It's really important that you've got clauses in there to say that any kind of invention that's developed by an developed by an employee during the course of their employment is owned by the company. And sometimes people can get tripped up if they don't have some kind of clause in there to that effect. Is it new? So again, as I talked about before, one of the key requirements is that it hasn't been published or commercially used or even secretly used before you file the application. If it's not new, it's not going to be patentable. If it is new, yay, you've ticked another box. Will it make money? This is kind of a blanket statement, and I think there are instances where you might still consider to patent even if it's not going to make money. So it could be that you're trying to develop a minefield, for example, around your area of innovation to block out competitors. And even though you might not actually commercialize something yourself, you might still want to file a patent in that space. But you probably want to understand in the big picture of your strategy, how is it going to help you, ultimately be successful? So it might not indirectly make you money, but what is the bigger picture there? If it is, yes, going to make you money, things are looking good. Have you sufficient cash? If you don't, you need to be thinking up front. If we do want to go through this process, how are we going to get the necessary money on board? Think about licensing, fundraising, loans, or alternatively keeping it as a trade secret. This is a really important consideration for startups. Often when money's tight, they've got no cash coming in. It's a very hard decision to kind of dedicate time and resources towards patents, but it's also on the flip side, very important to have an IP strategy and be able to convince your investors early on that you've got a position that you can protect. And they'll most likely, if it's in this area of food and beverage technology, and if it is something that's quite innovative and new, they will probably want to see that you've got some kind of patent protection, even if it's in a provisional state. Is the patent timeline fast enough? Yes, this is important. Like I said, sometimes the patent can take upwards of 5 years to go through all the way to grant, but there are ways of speeding it up, within a couple of years in key markets, if you need to. But if that's still not fast enough, say you're something that is a new SKU that's going to go in and out of fashion within a year, it's probably not going to be something that you really want to focus your time and money on is patenting. Maybe you want to focus on marketing or putting more money towards R&D for the next SKU that's going to come up. Can it be reverse engineered? This is an important one. Most of those examples I ran through ultimately could be quite easily reverse engineered. Potentially, the only exception to that is some kind of method of manufacture, if it can be kept as a strongly held trade secret. And then finally, in this, if you've answered all these questions, it's all looking good. You can see a patent attorney at that point. But when I was looking at this before, there are actually a number of these points here where it's very useful to sit down with the patent attorney and discuss them up front, and they can help you along the way. So the ones I've highlighted here with stars, we can actually sit down with you and talk through those. Another one, for example, have you sufficient cash? Although we're not going to obviously be able to help in that sense, we do have a lot of connections, angel investor groups, potential government grants. We deal a lot with these agencies, and there might be that we can just put you in touch with groups that have funding available for you to consider. Okay, where are we up to now? So, ways to leverage your patent to make moolah. I think this is an interesting one that everyone's obviously very wants to know about. How can they actually make money and so forth. Where am I up to? Let me just get my notes for this one. So, I think in terms of attracting capital, this is, like I said, this is a really important one. So, early on in the process, you need to be able to demonstrate to investors that you've protected your patent. If it's not through a patent, it's through tightly held trade secrets or important agreements that you've got in place, or it could be some other form. You've done a clinical trial and you're well on your way to being able to get a self-substantiated health claim, for example. But in terms of attracting capital, it's really important that you've got an IP schedule, so you've identified all of your IP rights, that you're enforcing that internally, so you've got a policy that you're using, and that you're able to show to investors as well that you've actually conducted some kind of SWOT analysis to show what are your strengths, weaknesses, opportunities, and threats when it comes to the IP side of things. That is really important for attracting capital. And if you've got a patent in there, even if it's pending, it'll be very, very helpful in terms of trying to get that initial funding on board to keep your project going. The next one is marketing collateral. So a lot of companies that I deal with will actually mark their products as patent pending. They'll often have a couple of comments on their website about it. They might put something on social media about how innovative they are and they've gotten a patent granted, or they've filed a new patent application for a new area that they're exploring. These are all kind of really interesting ways of, even though the patent might not be granted, you can still use those tools to kind of drive interest in your company. You can use that for actually gaining sales and market, which actually I forgot to mention right up front. Probably the easiest way of making money is obviously to commercialize your product. So that's number one, of course, but these are the kind of the alternative things that you should be thinking about. The third one there, attracting talent and retaining talent. This is a really interesting one that people often don't think about, but a company that kind of demonstrates itself to be innovative is often one that people will want to go and work at. If you can also, set up systems internally within your business where you kind of say, if you develop a new invention and we go through the patenting process and commercialize it, we will agree to give you 10% royalties of sales or whatever it is. There might be some kind of kickback to not only attracting but retaining talent in that sense. Even just the ability to be named as an inventor is a really great thing for a lot of people. A lot of people take a lot of pride in that, and so I think that's a really good way of retaining talent internally. And if you can retain talent, often that is the most important thing in terms of future growth of your business as well, and ultimately sales and profits. Licensing, this is a common one that people look at, and I think what's really important about licensing is, as I mentioned, patents are territorial, and they can also be sliced and diced in many different ways. So if you've got a patent that has got potentially different, so for example, the fruit sorting one, that fruit sorting one might have application to multiple different types of fruit. You could potentially license the patent rights towards, say, apples, and you could have another license agreement for oranges, and you can have multiple income streams coming in from more than one licensing agreement, and potentially you could actually negotiate some kind of deal where you're able to commercialize it yourself, as well as having these licensing streams of revenue coming in as well. You should also think about in licensing. So instead of going to develop technology yourself, a really important thing to consider is, have I done a search to see whether or not there might be some patents out there that, or technologies that might be patented as well, but that allow you to kind of in-license that technology and get you to market faster, and might be very complementary to your own intellectual property and capabilities. Deterring and stopping copycats. This is something you want to be able to do, doing regular kind of competitor searches to see what your competitors are doing in market and potentially the IP space. In terms of, you can potentially block competitors by sending them cease and desist letters once your patent is granted. Obviously, if your competitor is not in market, then you're more likely to have a greater share of the market itself and therefore drive revenue. And another key one I think people often overlook is that the copycats can often come from internally within your own business. So when you've got staff that leave, they've obviously got a lot of the intellectual property in their head. If they go off, they're going to go, how could I potentially, develop something with my new employer? They've got all of that know-how, that information in their brain. So by having a patent filed, it will deter that staff member from going off and potentially using that IP to their advantage in their new employment. And then I think in terms of exit strategies, this is another big one. So if you've got your patents protected, and perhaps you've got some trademark registrations and some few other things, that is a really nice package to be able to offer when you're selling your business or exiting. That is something that can really boost up the total value of your company and will help to kind of drive the conversations around what it is they're actually buying. So we see that time and time again, and is in the food and beverage sector, it's becoming more and more common. You see these startups that build it up to a certain level, and then the large FMCG companies will go and purchase the new startup, which typically will have some kind of key elements of intellectual property associated with it, and quite often patents. Okay. So now I'm going to talk about the mock case study, the Husky packaging. So what I'm going to do is I'm going to run through the story with you, and then I'm going to kind of highlight the key elements of IP that they've utilized, particularly around the patent side, and then how they've kind of leveraged those patent rights to drive revenue. So this is called Husky packaging. The CEO, Stacy, decided this was. Oh, sorry, I missed. Give me a second, sorry. I seem to have missed the first page, so I'm going to have to wing it off the top of my head. So this is Husky packaging. So we'll start from scratch. So this company was a Fijoa development company. They've been producing these Fijoas and selling them mainly in New Zealand, but they want an opportunity to grow and export the Fijoa market offshore. The only problem with Fijoas, as many of you will be aware, is that they have a very short shelf life, and it doesn't make very good export opportunities. So this company got together in the boardroom and decided that what they needed to do was kind of think about how they could potentially stabilize their Fijoas so it could be exported. And one of the ladies in the group, her name was Aroha. This is all mock, by the way. Said, like, my parents have a cornfield, and what I've noticed is that the corn husks that are left on the ground, we threw them into a bin, which happened to be next to some Fijoas, and what we noticed is that the Fijoas that were next to the corn husks actually ended up staying riper for longer. And I thought it was quite bizarre, and I'd like to explore that further. Maybe there's some way of using these corn husks that are normally chucked out. Maybe we could use this as some kind of innovative packaging. And the CEO absolutely loved this idea and said, yes, Arrow, I'd love you to go ahead and explore this. And so what happened next was Aroha said, the CEO said, I love your idea. If you go ahead, I'll give you some funding to explore this further. And if we get this off the ground, and if we get something patented, I'll give you 10% royalties for any commercialization of the IP. So Aroha got really excited, got straight to work. She set up a short research collaboration to investigate the merits of the idea, to validate shelf life extension, sensory results, and supply logistics. After 3 months, things were looking encouraging. Aroha developed a process to first mulch the corn husks, then formed them into an intriguing-looking matrix sleeve designed to encase and protect 10 fijoas at a time. The results showed that not only did the fijoas have 5 times increase in shelf life, but their flavor profile was optimally retained during this time. The mulching also seemed to be key to the shelf life, which in later trials Arrowhead determined to be because of a protective compound that was released into the corn cell walls. Arrowhead then went above and beyond to test and show that the levels of healthy flavonoids miraculously were twice the level normally found in fijoas, and were linked to the improved flavor. Knowing she was onto something, Arrowhead got internal approval to protect the IP and commercialize the product. Before doing so, she also expanded the trials to show the technology worked for other fruits and vegetables too. After engaging a patent attorney to do some patentability and FTO searching, Arrowhead wasted no time and prioritized filing a patent application for different aspects and uses of the technology for fruit and beverage preparation. Arrowhead also filed a design application to protect the unique look of the package itself. And supply agreements were put in place with the local corn growers, doubling to offer a nice circular economy story to market to their consumers. Third, to protect the marketing aspects of the product, Arrowhead developed 2 new trademarks, one which she called Flavo 50 Plus, to explain the flavonoid levels, which they could validate, and another for the name of the unique packaging sleeve that Arrowhead called the Husky. And then the Husky was launched. 2 years on, their sales had quadrupled as the new markets developed in South Korea, Middle East, and Malaysia as a result of the extended shelf life and the superior flavor, and the innovative story of the Husky's sustainability. Arrowhead had been promoted to lead the expansion of the technology through licensing deals of the patent to other fruit and vegetable companies beyond Fijoa, further increasing the business's income stream and its purpose of supporting health of the planet and its people. The company, which I forgot to mention at the beginning, is called Fruitsy, is now undergoing exciting new clinical trials to test whether the Flavo 50 Plus Fijoa fruit increases immunity health outcomes and infant nutrition through high-value nutrition funding, offering new ability to add value to their business through health outcomes. So I know that was really long-winded. I got a bit carried away with it, but hopefully you could kind of see some things pop out there in terms of IP strategies and also how they're actually gaining money from their patent as well. So just to kind of summarize, they in the employment agreement, which I forgot to mention at the beginning, but the CEO said, as per the employment agreement, I will give you those 10% royalties if you push it forward. And that way it really gave Arrowhead the incentive to kind of really push forward and stick with the company and take this all the way through to market and do well. They went through searching processes early on to determine whether or not there's something that could potentially block them and whether or not it's likely to be patentable. They got their design, patent, and trademark rights, and they set up licensing deals as well for an area that they weren't necessarily interested in themselves, but they could generate passive income through other fruit and vegetables as well. And then probably because they've done so well up until this point is why they managed to get HVN funding to carry out clinical trials. So the idea of having all these intellectual property rights up front helped to kind of convince funders to give them money to do further trials to, boost up the health attributes and potential health claims or future patents around this space. So hopefully you can kind of see some of those elements coming through in this case study. This was totally made up. There is no relevance to any client or anything like that, but I'm quite interested to know if it would actually work using corn husks. So if anybody has any ideas, I'd be really interested to know. So that pretty much summarizes it. I just wanted to bring everyone's attention to the next Scanning the Horizons webinar that's coming up on the 20th of April. So some of you might have come to the one on the 28th of February. We've got one coming up on the 20th of April, which is looking at the global food trends in the food for health space. And also Michelle from Smart Regulatory Solutions will be focused on the regulatory toolkit for exporting. So that should hopefully be a great webinar. And if you haven't seen the link to sign up to that, hopefully that's coming out soon. And I look forward to seeing you there. I think, I've just got one more slide. This is Spruson and Ferguson in a nutshell. I won't go through everything, but we're biggest firm in Australia, won heaps of awards, and got a lot of patent attorneys with very unique specialties in different subject matters. In the food and beverage sector, for example, like I said, you've got one area of patenting is around that kind of machinery and tools. So we've got a whole team that's focused on engineering type inventions that can help in that space. And then finally, just wanted to highlight, as I mentioned in the last webinar, we've got this IP hub, technology transfer hub on our website that's free access. So I strongly recommend for people that are in this space and looking at technology transfer and IP generation to look here and sign up. You get free access to it, and it's got tons of useful information. So with that, I will hand back to Mike and answer any questions that have come up. Thanks.
Great. Thank you, Peter. That was an excellent presentation. And I see a couple of questions have come through. Now for the tough questions, Peter. So let me just go to the first one. So let me see. If I just received a government grant to conduct a new R&D project, when should I talk to a patent attorney? So I suppose maybe the question there is, should you talk to your patent attorney before applying for the grant, when you have notification that you've successfully received the grant, or maybe at some stage later? What are your views there, Peter?
Yeah, thanks, Mike. So I'd say that it depends on the circumstance, but often in these grant applications, there might be a component there where they're asking about IP considerations. So have you conducted a due diligence search or an IP search? So often in those circumstances, it'd be really good idea to speak to a patent attorney and do that initial search up front, and to kind of get some kind of straw man ideas about where you might be going from a patenting point of view. But I think certainly if you haven't done so at that point, if you have received the grant, would be an ideal time to sit down and talk about IP strategy once the grant has been awarded, and certainly well before you actually go through and actually start doing the R&D from that grant, which could be a couple of years worth of funding. You definitely want to make sure that you've got a very clear kind of idea of where you're going from an IP lens on that.
Great. Thanks for that. And then there's another question here I can ask you. Is it better to file a patent before going to speak with a large collaborator, potential large collaborator, or wait until after collaboration and file jointly together? It's a tricky question.
Yeah, it is. And it's I actually had this debate with a group of people a couple months ago, and there was very differing views on this one. So, and again, it depends on the circumstance, unfortunately, but we always recommend, I guess, the fallback position is that you should secure your IP rights before going to speak to a collaborator, because you don't know how they're going to react. Sometimes an NDA is not sufficient. You want to protect your position before you go into any kind of negotiations or discussions about collaboration. I think the other reason why doing it that way is it clearly defines what you came to the table with. If you've just got it down as trade secrets, it gets a bit murky in terms of what it is you're bringing to the table. There potentially might be instances where you might not take that approach. For example, if you're going into a collaborator with very little, it's just an idea, for example. But again, it really depends on the circumstance. There's no reason why you can't go and file a patent application following the collaboration where you've developed new improvements or modifications to an invention, and it can be tailored to the outcome where you're working with the collaborator and they can see a potentially different commercial opportunity than you did originally.
Yeah, that's great. Thanks for that. Totally agree with all of that. And then maybe we've just got time for one more. And I think you might have touched on this in your roadmap discussion. which is what are the key time points during the patent journey that large costs come up, and how can I best prepare myself for that?
Yeah, I did cover that. So yeah, essentially the three time points I would say would be around when you file that original provisional application is the key first cost. Not a lot of money typically at that point, so you normally can cover it yourself. But yes, when you get to that PCT phase and or the national phase is where the costs start creeping up. So you want to be starting to uh, develop those you know, funding opportunities well in advance of that. So you're not suddenly scrambling just before those costs come up.
Okay, well, that's great. So we're just on time now, which is great. So thanks very much, Peter, for a great presentation, very informative. I believe we'll be corresponding with everyone after the event with a link to this recording and the slides as well. So I'd just like to thank you for attending today, and if you've got any interesting questions to ask Peter, his contact details are on the screen, and we will see you next time. So thank you.
Thanks a lot.